If you are a student and would like to join, please contact us by emailing dolesab@ku.edu or speaking with a student worker after the program. A video of today's program will be available on our YouTube channel soon. You can also access videos of past programs by visiting our YouTube channel at any time. The Dole Institute's mission is to foster civil and respectful discussion around important and often difficult topics. Please phrase your questions with this in mind. Before we begin, I'd like to remind you to please turn off all of your cell phones. And now please join me in welcoming Director Audrey Coleman.
Thank you, Sarah. Can everybody hear me okay? Good evening, everyone. Thank you so much for being here. This is the finale of our spring 2022 programming season, and this format is a little unusual for us, but it's one that is a fan favorite for sure. This event is a cross between a trial and a debate and is inspired by the Counselors series established by our previous director, Bill Lacey. Those of you in the audience are probably very familiar with the Dole Institute and our student culture, and in line with our institutional mission and traditions, it's been a real pleasure to reconceptualize and try something new this time around to see, to build this program into a mentorship opportunity for our students here at the Dole Institute. Huge thanks and gratitude to our counselors, Pedro Irigonegaray and Ed Duckers, for being the mentors to our students and recruiting the expert witnesses, and for all you've done for this program. This is going to be a lot of fun. You all in the audience are really going to enjoy this. Before I take any more time, I want to dictate the resolution that we will be discussing this evening, which is antitrust laws should be expanded to regulate anti-competitive practices by big tech corporations. I'll turn the floor over to Pedro and Ed for their opening statements. Mr. Irigonegaray.
Ms. Coleman, before we commence, Mr. Duckers and I would like to take a moment and say a few words about you. Ladies and gentlemen, Mr. Duckers and I have been doing these programs now for a number of years. And it is our great pleasure to welcome Audrey Coleman, whose new energy and enthusiasm for the program brought us these wonderful students for us to work with. And Ed will say thank you as well, but we wanted to take a moment to say thank you to you and welcome to the program.
Thank you, sir.
And it seems to me only appropriate in the house that Senator Dole built, or I should say Senators Dole built, that I should adopt Senate nomenclature. And so I would like to associate myself with the remarks of the distinguished gentleman from Topeka.
Thank you, sir.
Thank you both. Mr. Irigonegaray, would you like to open with your statement?
I would. May it please the court. Good afternoon. Welcome to the counselors. Our program today will address the question whether or not antitrust laws should be expanded to regulate anti-competitive practices by big tech corporations. I propose, following our presentation, the answer each of you will reach is a resounding yes. We will present two experts for your consideration. First, we have Professor Tarun Sabarwal. Professor Sabarwal has a PhD in economics from the University of California at Berkeley, which was awarded in the year 2000. He has a MA in mathematics from the University of California at Berkeley in the year 1999, an MBA in finance from the University of Cincinnati, and a bachelor's in commerce from Punjabi University in 1989. Professor Sabarwal is a professor of economics here at the University of Kansas from 2020 to the present. He is the director of the Center for Analytical Research in Economics from 2019 to the present. He's the associate editor, International Journal of Economic Theory from 2021 to the present. And he's a trustee and board member, self-graduate fellowship programs from 2021 to the present. In addition, I only mention a few of his distinctions and awards. He is an economic theory fellow of the SAET from 2020 to the present. He's a senior administrative fellow of University of Kansas from 2018 to 2019, as well as many other awards and credentials. You will have the privilege to have Ms. Catherine Magaña performed his direct examination. She is a student here at the University of Kansas in her third year, studying political science with minors in linguistics and environmental studies. She's from Wichita, Kansas. Catherine Magaña is the Student Advisory Board Coordinator at the Dole Institute of Politics and is a former discussions group coordinator. She's also a member of the KU Student Safety Board and Phi Alpha Delta, and is the recipient of the National Hispanic Scholarship at KU. Our next expert will be Ruth-Anne French-Hodson. Ms. Hodson is a highly competent and highly educated attorney. She's a partner in the Sharp law firm, involving herself with complex consumer class actions and appeals. Before joining the firm, Ms. French-Hodson worked at a national defense firm doing major consumer and pharmaceutical company cases. She is a graduate of the Yale Law School, the University of Oxford, and the University of Kansas. Needless to say, she's highly qualified. Her direct examination will be performed by my co-counsel, Michael Scott, a junior at KU from Glenview, Illinois. Mr. Scott is majoring in political science and economics with minors in environmental studies and Spanish. He competes on KU's debate team, and recently they reached the semifinals of the National Debate Tournament, debating the topic of antitrust enforcement. He is currently the research assistant to the Dole Institute director, Audrey Coleman, and was this year's Hemingway Scholar. Ladies and gentlemen, thank you for being here. Thank you for your attention. We look forward to our presentation.
Mr. Duckers.
Thank you, Judge Coleman, Mr. Irigonegaray, ladies and gentlemen of the audience. The topic tonight is antitrust laws should be expanded to regulate anti-competitive practices by big tech corporations. It's a topic that's full of problems. The number one problem is it starts from the assumption that existing antitrust law does not regulate big tech corporations, whoever that is and however that's defined. And that's simply false, as our expert witnesses will testify to, and as I'm sure both of the experts on the other side will acknowledge. Also undefined in this is what is big tech, and who are they singling out for preferential treatment, and what do they mean by expand? These are the topics that we are going to be exploring. The fact of the matter is that antitrust law has one purpose and one purpose only, and that is to prevent consumers, people like you, from paying higher prices as a result of unlawful output restrictions or experiencing unlawful output restrictions because of higher prices. That's its sole purpose. Antitrust is not Festivus. It is not an airing of the grievances of whatever other problems you might feel about data gathering or wage inequality or things of that nature. It's focused on protecting you, the consumer, from output restrictions, higher prices, and restrictions on innovation. And efforts to regulate that are ill-conceived like this plan do nothing but harm the economy, harm the competitive process, and harm you. You know, monopolization, it's not illegal to have a monopoly in this country. In fact, monopolization, or the ability to acquire monopoly power, is the engine that drives the economy. And that's been true under Supreme Court precedent for well over 50 years. The most recent articulation of that proposition was in the Trinco case in 2004, and this is important to understand. Monopolization requires, in addition to the possession of monopoly power in a relevant market, the willful acquisition or maintenance of that power as distinguished from growth or development as a consequence of a superior product, business acumen, or historic accident. The mere possession of monopoly power and the charging of monopoly prices is not only not unlawful, it is an important element of the free market system. The possession of monopoly power will not be found unlawful unless it is accompanied by an element of anti-competitive conduct. In other words, if you invest your time and your money and you take the risk to build a better mousetrap and you succeed and consumers storm to your door to buy your mousetrap, you are entitled to benefit from that. That is your reward for having made that investment. And that's what drives innovation and growth in the American economy. And that is what the proponents of this proposition seek to take away from you. I am going to present, or we are going to present on our team, two witnesses today. Jeffrey M. Cross is a partner at Freeborn Peters in Chicago. He's been practicing antitrust law for over 40 years. He's an adjunct professor of antitrust law at Loyola University, and he recently completed writing the section on Section 1 of the Sherman Act, which is multilateral anti-competitive restraints of trade, for the judicial desk book that judges use, that district court judges use. In other words, he is literally the guy who wrote the book on antitrust law, and he will be your first witness. He will tell you that in a market economy, monopoly is not only lawful, it's the engine that drives innovation and price competition. He will explain to you how the consumer welfare standard employed now prevents real competitive harm, and he's going to show you how application of current law to so-called big tech is more than adequate to protect you from competitive harm. The other witness is Tripp Monts, who's a partner at Hogan Lovells in D.C. He has an economics degree from Yale, if I recall correctly. His law degree is from South Carolina. He's one of the foremost academic thinkers in the litigation circuit, representing both plaintiffs and defendants, and he will explain to you the benefits of consistent, empirical, and a data-driven approach to antitrust enforcement. He's going to explain to you how we've tried the other side's approach. Nothing that is being advocated for today is new, believe me, and we've been on the wrong side of this question before, Tripp and I. It's not new, and what we know is it has always failed miserably, it has destroyed national wealth, it has deterred lower prices and innovation, and harmed you, the American consumer. And he's also going to explain how the other side doesn't even know what it wants to do or who it wants to do it to. Raina Peters will be examining Mr. Cross. Will Menching is examining Mr. Cross. Raina is examining Mr. Montz. I asked to put on their biographies in detail like Mr. Irigonegaray, but they said, no, use the time to make argument. These kids are killers.
Thank you, Mr. Duckers. Ms. Magaña, would you call your first witness?
I'd like to call our witness, Dr. Sabarwal, to the stand.
Okay.
Thank you for being with us today, Dr. Sabarwal. I understand that you are a professor of economics and have knowledge of antitrust law and how it functions in relation to the economy. My first question for you today is there an economic justification for antitrust policy?
Thank you. the theory of markets provides an economic justification for antitrust policy. When individual firms make decisions to further their specific interests, profit maximization, or their particular interests, those decisions have external effects on other market participants. So for example, a firm's decisions can affect the competitive landscape in an industry. Their decisions can affect consumer welfare. A firm's decisions can affect the workers' opportunities for workers. Their decisions can affect innovation in the economy. And another aspect which I will try to convey is more relevant to antitrust these days, is that a firm's decisions in one market may actually contribute to competitive changes in the competitive landscape in a related market. And it can, and similarly can affect the conditions for consumers in another market, affect the well-being of workers in another market, and can affect the innovation process in other markets. So antitrust policy can be viewed as trying to regulate these externalities to provide a more level playing field. So broadly, antitrust policy benefits competition, benefits consumers, benefits workers, and can benefit innovation.
Thank you. My next question for you is that it feels like a simple idea that more regulations, specifically antitrust policy, should be hurting competition because they constrict companies from being able to do what they want. So how does antitrust policy improve competition if there are more laws being put in place?
That's a good question. The logic of profit maximization will drive a firm towards becoming a monopoly, because that's what gives the highest profit. And a monopoly, of course, is viewed as the epitome of lack of competition. There's no other firm to compete with it. So one way to think about the question is, without antitrust law, with more and more movement toward monopolies, you will actually have less and less competition. So in that sense, antitrust law can be viewed as providing a sort of some degree of fairness in the competitive landscape.
Thank you. Can you tell us now what is the consumer welfare standard and what are its effects?
This was also mentioned a few minutes ago. The consumer welfare standard seeks to prevent harm to consumers in an industry from the actions of firms in an industry. It's a central component of antitrust policy. For example, if two firms are planning to merge, and the likely effect of that may be that prices will go up, then antitrust law can step in and prevent that merger from occurring. Consumer welfare, of course, doesn't just depend on prices. It can depend on many other variables. For example, as was mentioned earlier, can also depend on the output levels, can depend on the quality of the products that are being provided, can depend on the quality of the services, ancillary services that are being provided, and can also depend on the scope of products that are being made available to consumers. So the effect of the consumer welfare standard is to try to design aspects in antitrust policy, in antitrust law, that will try to prevent harm to consumers.
Absolutely. Tonight, one of the main things that we're discussing is the idea of big tech and monopolies. What are the potential risks with these dataopolies and big tech?
As was mentioned earlier, a firm may grow big by providing great products and services. That's great. The problem is that a big firm with deeper pockets may find it easier to bully competitors or consumers. It can make decisions. It just may make it easier for such a firm to try to curtail competition, or to try to extract more advantages out of consumers, or to try to extract more advantages out of workers, or to try to curtail innovation where it may benefit its bigger status. And of course, one thing that I will talk a little more in a few minutes is that largeness, because of the interconnectedness that's more central to the types of big tech companies we are thinking about, the largeness of one firm in one industry can be used to have harmful effects in related industries. So that's some of the things that may be potential risks with big tech. Now, similarly, a dataopoly is, again, it's a not very well-defined term, but can be viewed as a situation in which one platform, an online platform, can access considerable amounts of data on its users and can use this data to increase its profits, sometimes at the expense of users. For example, Amazon collects a lot of data on third-party sellers, data that these sellers may not ordinarily share with other firms. But in their relationship with Amazon, they have to share this data. And Amazon is a big company. It can use data on these firms to try to design, copy some products that are successful and to give them a preferential placement on their platform. Similarly, Facebook collects a lot of data on its users, data that users may not ordinarily share with others. And Facebook can use this data to try to influence consumer or user engagement in ways that can increase its profits and sometimes, perhaps, harm the users. So broadly, the bigger voice that these firms have is a concern. It may be a bigger threat both for competition and for consumers. And it's in this sense that this may be a reason for regulators to at least scrutinize the big tech firms more.
Absolutely. Can you give us some examples from big tech where antitrust policy might become relevant?
Yes, several. So these days, this is a lot of discussion of these ideas. And if you want to organize this in your mind about the types of, some of the new types of arguments that are coming up, you can think in terms of network externalities, or I said, dominance in one market affecting competition in another market. So take the example of Google. If you go to the Google search engine and just type in MCI space ORD, okay, and press enter, you'll get a list of flights from Kansas City to Chicago O'Hare, along with some variations in the prices, and along with some other information about what are good, cheaper days to fly, more expensive days to fly. That's the first thing you'll see. Below that, you will see links for online comparison shopping firms, the Kayaks, the Orbitz, Priceline, and so on. So 2 points. Most of us, when we do a search, we look at the first option, looks good, let's try to solve our problem there. We don't have time to waste to do all this additional shopping. Related problem, this immediately affects the flow of traffic to these other comparison, to the online comparison firms. These firms live or die based on the number of visitors to their websites. So Google, trying to develop a better search engine, has this externality that it may affect competition in a related industry. Another example is that's received a lot of coverage in the last few years, is the monopoly that something like an Apple App Store or a Google Play Store will have. For example, Spotify and Epic Games have disputed with Apple that the types of, the amounts that are being charged as fees to access consumers through the App Store are unreasonable in some cases. So for example, if Spotify goes through the App Store and connects with the consumer, Apple says, we provided you with this great number of consumers. You've been able to access some of them. It'll be nice if you compensate us for this. And Spotify says, yes, that makes sense to me. So they pay, and the numbers that I hear is it can be as high as 30% of the revenues of the sale price. So now Spotify says, okay, once this connection has been made, the ability of a consumer to stay with Spotify has nothing to do with Apple anymore. It's just the quality of the product Spotify provides and whether a consumer likes it or not. But Apple would still require on sort of recurring subscriptions to charge Spotify their fee. So that has been a bone of contention, similarly with Epic Games. So that's one part, changing the cost structure of a firm in another industry, because you control one part of a different industry. But the second part is Apple itself is providing a competitive service, the Apple Music. And that, of course, is not paying anything extra. So in an effort to try to make the best case out of making money off the App Store, it has this consequence that's actually given a significant disadvantage, a 20-30% hit to revenues to Spotify to compete with its own product. Similar stories about Amazon and so forth. In the last couple of minutes, I wanted to say something about the Digital Markets Act in the European Union, which is trying to make interoperability across messaging platforms. But taken together, these arguments show that antitrust laws should be expanded to regulate anti-competitive behavior by big tech corporations. Thank you.
Thank you. Those are all the questions I have.
Ms. Peter, you may cross-examine.
Dr. Sabarwal, I want to start with your understanding of the consumer welfare standard. So it's your understanding that the consumer welfare standard does not only relate to price. Correct.
So the consumer welfare standard, there are different versions that are applied in different cases. The standard version from economics would be something called consumer surplus. Okay. Consumer surplus is the idea.
Yeah, just yes or no. Is that what the consumer welfare standard does? It does not only relate to price, yes or no?
I think it relates to things more than price.
Okay, yeah.
Yes.
So you believe the standard strikes against practices that harm competition in other ways, such as reducing quality or stifling innovation?
Yes.
Then what's ineffective about it in the status quo? If it's doing those things, if it's preventing those forms of anti-competitive conduct, then what's the necessity to abandon it?
That's a very good point. So I'm not arguing that the existing framework is useless. So I'm sure it has its uses. And to the extent that it allows us to apply the principles of antitrust policy to affect the desired outcomes, for sure we should use it. Now that also doesn't mean that it's going to be able to answer all the questions that are being.
What questions does it not answer?
So for example, these days, so one of the things that's traditionally been missing both from the theory of antitrust and the theory of industrial organization is the effect of cross-market effects. That typically requires a heavier analytical machinery.
Okay, yeah. If the consumer welfare standard is able to prevent anti-competitive conduct in one market, then how will it have those spillover effects that you mentioned earlier?
Oh, because the channel for those spillover effects is different. It's not the consumer in that one market. It may be different consumers in the other market. Okay,
so this proposition that would include analysis of these different channels, what does it do differently? You mentioned in your testimony that it would the regulators would increase their scrutinization of big tech companies, but what does that mean? What does it mean to just increase scrutiny?
That's a very, okay. You have very good questions here. So one, I have two comments on that. One is almost any intellectual endeavor is not done. Right? So we're never done. So yes, so we should learn from our past. We should learn from what has worked and try to modify that. And if that means passing new laws, then that's fine too.
Okay, awesome.
But we are also learning our knowledge, our scope of understanding is also increasing. So just because antitrust policy may be doing some things right, that doesn't mean that and for sure, some of the new tech, these big tech firms, may be suffering the same types of problems as the earlier big firms.
Question about big tech corporations. Is Apple a big tech corporation?
What do you mean by a big tech corporation?
I mean, it's in the resolution and you're defending it, so.
And you are going against it, so?
A big tech corporation, the way that you define the market power concentration, would Apple be considered a big tech corporation that would be subject to antitrust regulations? So your argument is that we should expand antitrust regulations. Is Apple a company that would be subject to those increased regulations? Just yes or no?
I didn't understand the question. Could you please repeat the question?
Is Apple a firm that would be subject to the increased antitrust regulations that you propose?
I'm not proposing any particular antitrust regulation, but for sure, Apple, I personally would view as a big tech corporation.
What about
should be
Amazon?
Subject, please, and would be subject to the same types of antitrust laws that other firms are to be subjected to.
So would you also consider Amazon one of those companies?
I would say, so again, we have to, yes, I would say they would also be part of the big tech.
What about Netflix?
I'm not sure I follow the argument here. What is the point?
Well, it's just a yes or no question. It's not an argument, it's just a yes or no question. Is Netflix considered a big tech corporation that would be subject to increased regulations?
So let me say it a different ways because I'm not sure what's being really asked here with these yes or no questions, but so let me step back and say, what is the need for these new or additional rules?
Well, that's
so
your
the US,
argument.
Let me try to say that. So the US, for example, has come down on the side of, well, we don't really need as many new regulations. The existing ones are fine. Fine, that's a good argument. The European Union, on the other hand, is saying for these types of, let me call it big tech, but you can call them digital markets, because that's the Digital Markets Act. These types of activities, these types of economic transactions, market transactions, do need additional regulation.
Who decides what these companies are? Because you couldn't answer if Netflix was considered one of these big tech companies. So who decides who they are after we increase regulations? Is it just up in the air? Is it just arbitrarily decided? Or how do we know when these companies are big tech corporations that are somehow impacting the economy in a negative way that we have to do something about it? Like when do companies meet that threshold of anti-competitive conduct?
Very good point. And I would say we have rules, we have laws, and the laws have the scope of application. If these firms fall under that scope of the laws, they are affected by the laws. If they fall under the scope of the new laws, then they're affected by the new laws.
How do you know if they're
that's why we have our legal counsel here.
Okay. Another set of questions. You agree that we should not enforce antitrust laws against big tech firms just because they're big? Agree with
yes,
that?
I personally feel that, go ahead.
Just so that's because their size may result in benefits to consumers and other producers. So for example, one of the benefits of Amazon is that it allows a number of different sellers to reach potential buyers of their products on a single platform. And size may also result in inefficiencies to other producers, so as companies that supply big tech firm. So if we're going to have a rational antitrust policy, we need to strike not at size but conduct. Is that correct?
No, I think you have to look at both together. Just because you're large doesn't mean it's bad, but just because you're large also doesn't mean you're not bad. That needs to be decided by whatever is the process in place in an economy.
So the real question for antitrust enforcement against big tech or anyone else is determining what conduct or what part of that process harms competition, right?
Again, I didn't follow that question. Could you please repeat?
Yeah, so the real question that we should be debating with antitrust enforcement against these big tech corporations is determining what conduct specifically harms that process, harms the competition.
Yes, what practices, what decisions that they have made would harm competition, would harm consumers. And we haven't really talked about affecting competition for workers or affecting how their decisions may be impacting innovation. So those are also parts of the bigger question.
Okay, awesome. I have no further questions.
Thank you so much.
Thank you.
Thank you, Professor Sabarwal.
Thank you.
Mr. Scott, would you call your next witness, please?
Thank you.
I'd like to call Dr. French-Hodson to the stand. Testing, is my mic working?
Go ahead
Okay,
and test it, Michael.
I think it will turn on in a sec. All right, awesome. Thank you for joining us today, Dr. French-Hodson. My first question is, if we could go back a little bit into the history, and you could just talk about what exactly the Sherman Act is, which is one of the core antitrust laws, and what its original intent was in preventing monopolization.
Sure. I think it is really important to start with the intent and the text of the statute itself. At the end of the 19th century, this country was dealing with many of the same issues that we're dealing with today. Inequality, concentration of wealth and power in industries that are central to our economy, and a real exploitation of people in the center of the country who are not in that wealthy, in the wealth. One of the perceived causes at the time was Standard Oil, the railroads, and other trusts that had effectively monopolized entire industries and used their size and wealth to cause harm. The issues were not simply prices to consumers, but rather a broad set of concerns about the growing power of big business to exploit and manipulate those who relied on them, from farmers here in the Midwest, to labor, to small producers, and government. And if we look at how the Sherman Act was specifically drafted, it was drafted broadly to restrain trade and make monopolies illegal. While Councilor Duckers came up here and talked to you about case law over the last 50 years, those were judges interpreting the statute and not what Congress actually wrote. If we look at the statute itself, it makes every contract, combination, or conspiracy to restrain trade or commerce illegal. It also, unlike what Councilor Duckers says, makes it unlawful for any person to monopolize or attempt to monopolize or combine or conspire to monopolize any part of trade or commerce. Now, while case law over the last 50 years may have interpreted that in a different manner, it is important to look both at the text and the intent. As the Supreme Court has told us over time, that's what we should be looking at: the legislative purpose, the particular factual context, and the common law tradition that was being drawn on by Congress when they drafted those words. And in the case of the language on restraints of trade, Congress was drawing on a long tradition that had common law roots, that had courts examining the larger questions of fairness throughout the 19th century when they were talking about restraints of trade. And I think that's also historically how the act was enforced for a long period of time. In evaluating mergers early on, regulators looked at all potential harms, including how to protect competition in key industries, avoiding problems of too big to fail and not just price competition. Nearly a century ago, Justice Brandeis wrote, "We must make our choice. We may have democracy or we may have wealth concentrated in the hands of a few, but we cannot have both." And we are at a similar point today with where big tech is at.
Awesome, thank you. My second question is, speaking about today, do these big tech corporations constitute monopolies, and how are they undermining competition in the digital economy?
That's a really good question, and the importance right now of big tech in the current economy and our current time. I think the COVID-19 pandemic has really underscored the importance of internet access, of platforms of accessibility, and making sure that it's affordable, competitive, and widely available and fair to workers, families, and businesses. There's no doubt that companies like Amazon, Apple, Facebook, Google, the entities that we're discussing today, also play a really important role in our economy, and there's no doubt that they likely should stay around and continue to provide these resources. But having a fair infrastructure matters. We can, as Dr. Sabarwal really discussed, I think, earlier in the examination, there are lots of examples of how the bigness and their monopoly power has been abused. We can look at Facebook. I believe Dr. Sabarwal already talked a little bit about the data monopoly, but we could look at some of the typical measures that attorneys usually look at. We can look at market share based on daily and monthly users. Meta or Facebook has over 70% of the personal social networking market since 2016. That's easily within our normal ideas of bigness and monopoly power. It also creates a lot of barriers to entry that we typically look at when we think about monopolization. There's high switching costs. Users, all of our collection of content and our connections over time are stored by Facebook, and it's hard to get that out and try to go to a different platform. There's also direct network effects. Because there are lots of people on Facebook, it also is hard to switch. It's more and more valuable as the number of users increase. And Facebook has been able to do that by acquiring competitors and essentially killing those competitors that may have tried to take away market share, ones like Instagram and WhatsApp. It's also implemented and enforced policies that prevent interoperability of threatening apps that may, again, take content away. It's only really artificially appears to be good for consumers because it appears to be a free service and customized to users as they come along. But as we all know, and I think as Dr. Sabarwal noted, there is no such thing as a free lunch. The Facebook, like a lot of the other entities that we were talking about, essentially extracts wealth from consumers by taking their personal data without having to pay a fair market value for that data. It also capitalizes and makes money on the creative content from its users. And it also doesn't have really any pressure without competition to compete on metrics that matter to users, like data privacy. As a result, Facebook can protect privacy below competitive levels and collect personal data above competitive levels. It can also charge for all of the many small businesses that find important to be on Facebook to reach consumers. It can charge them artificially high prices, right? And so in order to advertise to consumers who you know this is going to be the best way to reach them, you're charged higher prices, and then consumers are hit in the end with having to pay for those advertising costs as well. And it's also harmful in other ways. We saw during the COVID-19 pandemic, there's a lot of desire to increase traffic to either Google or Facebook, and being motivated by clicks for content gets you pushing misinformation and dangerous ideas, rather than actually caring about what's good for our democracy. And I think Facebook, Dr. Sabarwal talked about some of the other problems with Google and the other entities. I'm happy to talk about them more. But at the end of the day, I think we can use these to look at the broader effects about how inequality has grown in our countries. And we've seen a harm to innovation over the last 20 years. New business formation is currently at a 40-year low, and it's declined by more than 40%. So while the attorneys on the other side were talking about how great competition is for innovation, that's simply not happening right now without good antitrust enforcement. Venture capitalists are hesitant right now to fund new startups. They've been very public about this because they see anything within the orbit of these big tech companies as within the kill zone and not worth their investment to go and fund. And so if you are someone who cares about tech and gadgets and scientific advancement, you should also love antitrust enforcement because it's important to let the markets decide rather than simply a court's decision or an upfront regulator decision on what's efficient or price competitive.
Awesome, thank you so much. So moving on kind of back to the law, the other side proposes that current antitrust law is already doing its job. What about current antitrust law has allowed these anti-competitive actions to happen?
Yeah, I think that there are a couple things that we can look at. The first is while there may be discussion of how antitrust law could be used, what we can see is that over the last decade, it actually isn't being used in that manner. Rarely are mergers rejected. And in fact, in this very industry that we're talking about, the big 5 tech companies have made over 436 acquisitions in the last decade with little to no challenge from antitrust authorities. There's also been a real lack of enforcement action, so you can talk a big game about how this could work in practice, but it's not actually being done. From 2000 onwards, the Department of Justice has only brought 1 monopolization case in total against anyone. In contrast, in the 70s, when, before the kind of height of the consumer welfare standard, just from 70 to 72, the DOJ brought 39 civil cases and 3 criminal cases against monopolies and oligopolies. And why is that? It's the consumer welfare standard and the real shift to, while I completely agree that it should be looking at a lot more factors, at the end of the day, FTC guidance and a lot of court guidance tells us, has us look at whether it's raising prices, whether a merger or conduct raises prices above a competitive level. And that simply should be rejected for both textual and practical reasons. We talked a lot about the textual reasons, and I can talk about them more about why we shouldn't allow judicial activism to overtake what is the legislator decided a long time ago, but also practically, looking at this up front can be we're kind of bad at predicting the effects on consumers, and as long as we protect monopolies and hope that something will come in and disrupt them, we maybe need to do more upfront to stop and give a broader analysis.
Awesome, thank you so much. Just to finish up, could you discuss some examples of how antitrust law could be improved to solve these current issues?
Definitely. I think there should be more enforcement. The FTC should be taking more action. The DOJ should have more courage. It shouldn't just be one big case every 20 or 30 years. But I also think that, and maybe it's something we can come to an agreement on, that a consumer welfare standard that means something is much broader than how it's been reduced to now, and that we should talk not just about efficiencies, but how can we help innovation and industries grow, because at the end of the day, the best way to protect consumers is to not just simply bring enforcement actions later, but have a really fair competitive market that's going to breed innovation and be able to check anti-competitive behavior without the need for moving to enforcement.
Thank you, no further questions.
Thank you, Mr. Scott. Mr. Mechnig, you may cross-examine.
Dr. French-Hodson, you opened your testimony with your interpretation of the Sherman Act, correct?
Correct.
And
I read the statute, yes.
yes, you read the statute, and then you offered your interpretation on what was illegal and illegal, or what was unlawful within that that framework of law.
That's correct. So I offered the statute, and then I explained both the legislative intent as well as the common law grounding of the words that were used in the statute.
So you invoked the common law grounding, and you said that all contracts that restrain trade would be unlawful.
That's what the statute says, yes.
Do you agree with that characterization?
I agree that that is what the statute says, yes.
So you agree that all contracts that restrain trade would be unlawful, using your interpretation of the Sherman Act?
Using the text of the statute, that is how it reads.
That is how it reads, and you spoke very positively of it, affirmatively of it, in your opening testimony. So wouldn't you agree that all contracts restrain trade, and that all contracts would be unlawful given your textualist interpretation and reading of the Sherman Act? Even the media release you signed this morning, it said that they can use your likeness, and now you can't for it, and the Dole Institute could conceivably profit from it. Doesn't that restrain trade? And wouldn't it be unlawful given your characterization of the Sherman Act?
Yes,
Yes, it would be. So all contracts, one of the bedrocks of the common law tradition that you invoked, would be illegal under this characterization of the Sherman Act.
All contracts that restrain trade.
All contracts restrain trade. You just said that.
I'm not sure that's what I said, but regardless of whether it's an effective statute or not, that's for the legislature to decide. Now, there is some room for interpretation. I think what I said in the common law.
You want to broaden the concept of the consumer welfare standard, correct?
Correct.
You invoke privacy, you invoke labor, you invoked all these other concerns beyond, productive output.
Beyond price and efficient.
Beyond productive output.
And allocative efficiencies, yes.
So you're looking for a much expanded consumer welfare standard, or standard of some kind.
Correct, and I think that goes back to the common law tradition of fairness.
The Department of Justice, it publishes relatively transparent guidelines on what mergers may be unlawful. It uses a number of indices. So it's a clear, rational standard for firms to use to, if they are looking to make an acquisition, to do these, to expand their business. Wouldn't you agree? You're aware that these guidelines exist?
I'm aware that the DOJ and FTC provide guidance on the Sherman Act, yes.
So, given an expanded enforcement regime, the DOJ is now going to have to write guidelines based on privacy, labor, all of these other things that have very little to do with that. So someone at the DOJ is going to offer guidance to make it clear for people on this is how we'll enforce this.
I think that's very reasonable, that they should have additional considerations and that there would be.
So a rulemaker at the DOJ
there would be
a rulemaker at the DOJ is going to just set this is the law, this is what it's unlawful and not.
If they are going to enforce the mergers, it is important for them to set out guidance, yes. And just as they now constrain.
This country has a number of laws. We have laws on labor, we have laws on privacy. Why shouldn't Congress just pass new law that perhaps provides new privacy protections or protects labor? If those are the issues, instead of shoehorning it into the realm of antitrust where it doesn't belong.
A good question. The antitrust, there are two answers, really. The first is that we actually don't have a national law on privacy. In fact, there are very few state laws on privacy.
This is the National Privacy Act of 1974.
Which does very little.
It's a national law, is it not?
It is, but it provides no protection for the things that have happened to consumers by the big tech companies. If it provided any teeth, we wouldn't be in those situations right now. Not only that, but there are the acts that we have and the monopolization issues about anti-competitive behavior. A lot of the issues with privacy and data go to the root of how these companies make money and their ability to exploit.
That's all well and good,
data.
but to be honest with you, I don't really think you understand, or I missed what I was trying to say with the beginning of that question.
Sure.
So if the government suddenly decides to increase antitrust regulation, put business decisions further under the microscope of regulations into all these new realms, how will innovation be protected? Innovation is one of the key components. Wouldn't it harm innovation, put it under all these new microscopes, new areas in antitrust?
Innovation will be fostered when companies cannot simply merge and take on their competitors and stifle new startups. We have the example of Google stifling competitors who had other search result possibilities. I think Dr. Sabarwal talked about the travel, but that's not just how they do it. They've also scraped the internet for content and take from creators who may be trying to make money and innovate, and the money and then put the same content in their top search results, so no one ever clicks on those innovators' results.
All right,
those
you're
companies go out of business.
Big tech here. I think it's important to define for the audience what we mean when we say big tech, or at least what you mean when you say big tech. You mentioned Facebook. I assume you think you would characterize it as big tech.
I would, and I discussed in my testimony.
Would you characterize Twitter as big tech?
I don't know the metrics on Twitter's.
What is Twitter's market cap?
I don't know.
It's $44 billion. Facebook's is in the trillions. Would you still
Correct.
characterize Twitter as big tech?
I don't know if I'd put Twitter in that category. I talked about Facebook because it does meet the metrics that I believe fit in, having over 70% of the personal social networking market since at least 2016.
What about Tesla? You know, Elon Musk is going to acquire, I think, Tesla. You know, they make a lot of technology. Are they a big tech company?
I think that's a different market.
In what way?
It is a automobile manufacturer. Now, it may be.
They make self-driving cars. They
Correct.
collect user data. It's all of the same things that you're talking about.
You know, that you make a really good point. Maybe they are a monopolist.
So
I'm not
is
sure.
the,
If we're
is
gonna
the
define-
is the Ford Motor Company a big tech corporation?
If we define.
Is the Ford Motor Company a big tech corporation? Is General Motors?
A big tech corporation.
What limiting principle do you?
Mr. Mechnig, your time has expired. Thank you, Dr.
I'm happy to
French-Hodson.
regulate them more as well.
And now, I believe Mr. Mechnig will present a direct examination of Mr. Cross for the negative case.
Hello, Mr. Cross. Would you begin just by would you please for the audience give a brief background and teaching, brief background?
I have been practicing antitrust law for 48 years. I have taught antitrust for 15 years, both at the University of Illinois, Chicago, as well as Loyola University Chicago School of Law. And as Mr. Duckers mentioned, in June of 2016, the Federal Judicial Center, which is the educational arm of the federal courts, asked me to write a basic primer for new federal judges on Section 1 of the Sherman Act. And I'm pleased to report that the hard copy of the book came out today. So,
Well, congratulations on the
you.
publishing of your new book. Let's focus on the major question, the fundamental issue of why we're here today. Antitrust laws should be expanded to regulate anti-competitive practices by big tech corporations. Mr. Cross, how do you view that issue?
I think right now the antitrust laws as written and interpreted by the courts and the federal agencies are sound and that they can address virtually every problem that arises with big tech. So I would say no, the antitrust laws do not need to be expanded.
All right, so antitrust law, what does it do?
Well, I think you need to step back and think about what our economy is all about, and that will help you answer that question. We're in a market economy, and in a market economy, companies produce and consumers vote with their dollars as to what products they want the producers to produce. That's how we allocate resources in the market economy, is having consumers vote with their dollars, make decisions as to what they want.
So are there any, would you say that there are other economic models?
Sure, let's contrast that with a government planned model like Soviet Russia or communist China, or a regulatory model, what we provide right now with, say, electric utilities. Electric utilities are natural monopolies. The government awards electric utility a monopoly. We don't want multiple companies putting electrical lines down our streets and roads and across farms. So we have one electric utility generally in an area, but because they're a regulated monopoly, we have commerce commissions that apply complicated cost formulas to decide how much their return on capital that they receive. That's a regulated type economy.
And what are the pros, cons of these different economic models?
Well, if you think about the market economy that we're in, we want to encourage people to innovate, to build a better mousetrap, if you will, or to apply business acumen to innovate. And we really want them to drive for a monopoly. That's the ultimate reward. And we want to allow them to have monopoly profits as an incentive to innovate and to develop a better product. Now, the theory is that new companies will come in and also offer another product that competes and knock down that monopoly. And that's where we get into the antitrust laws with the concept of barriers to entry and with big tech network effects being barriers to entry. But
No, what are those laws that govern antitrust?
so we've talked about so far today 3 basic laws. Section 1 of the Sherman Act says every contract, combination, and conspiracy is unlawful. Now, very early on, by the way, the Supreme Court decided that you can't read the Section 1 of the Sherman Act literally because, as you pointed out on cross-examination of the last witness, that every contract restrains trade. That's what a contract is all about. And so the court imposed a unreasonableness restraint of trade. This is generally considered the cartel statute. And cartel enforcement is really very good across the country. When I started practicing law in 1975, there were only 2 countries that had cartel enforcement, the United States and Canada. Now there are some 90 countries that have cartel enforcement. So that's really very sound. And then you have Section 2 of the Sherman Act, which is the conduct of single companies, and it prohibits monopolization or attempts to monopolize or conspiracies to monopolize. That word monopolization, it was chosen by Congress purposely. It's not monopoly, it's monopolization. It's the process of using a monopoly and applying bad acts to that. Then there's Section 7 of the Clayton Act, which is the mergers or acquisitions statute. The FTC DOJ guidance for Section 7 of the Clayton Act talks about the overarching principle of Section 7 is to prevent mergers that enhance or create market power, which is the ability to raise prices above competitive levels. I think if you apply that overarching principle, our merger enforcement is successful. So I want to focus on Section 2 of the Sherman Act, which is the unilateral monopolization statute.
So focusing on Section 2 of the Sherman Act, how might that apply to these so-called big tech companies?
Well, there are 2 elements to Section 2 monopolization. One is that you have to have a monopoly. But as Mr. Duckers read the selection by Justice Scalia in the Trinco case, monopoly itself is not unlawful. There has to be a bad act. So let's assume for a minute that big tech are monopolies. Let's talk about the bad act. What does it mean to have a bad act?
Let's assume that big techs are a monopoly for the sake of the argument. What would constitute an anti-competitive act?
So the model that I want to propose is the model that was adopted by the District of Columbia Court of Appeals in the Microsoft case in 2000. And in that model, there's a stepwise burden-shifting approach applied by the courts. First, the plaintiff has the obligation to prove a prima facie case of anti-competitive effect. If the plaintiff is successful at doing that, the burden shifts to the defendant to come forward with a plausible pro-competitive justification. If the defendant comes forward with a plausible pro-competitive justification, the burden shifts back to the plaintiff to knock that down as either being a sham or exceed the necessary amount of restraint to achieve the pro-competitive effect. If the plaintiff is not successful at doing that, ultimately the courts or the trier of fact will weigh the anti-competitive effect against the pro-competitive benefits. And that's how we determine if there is the so-called bad act under Section 2.
So that's pretty complicated. Is there a real-world example, maybe from the realm of big tech, that you can apply to this framework?
Sure. Let's take, as you all know, and by the way, in terms of antitrust enforcement, both the Department of Justice and the Federal Trade Commission have recently sued the most well-known big tech companies. The Department of Justice and multiple state attorney generals have sued Google in the District of Columbia. The FTC has sued Facebook, and Amazon has also been sued. So there are very vigorous antitrust enforcement right now going on against big tech. But let's take the case against Google in the DC trial court. One of the allegations against Google is the so-called anti-forking restraints. And by fork, I'm talking about a fork in the road. And as you all know, Google purchased Android, the Android operating system, a number of years ago. Android is open source. What that means is that anybody could take the Apple code and create whatever they want with the Apple code. The anti-forking restraints that Google imposes upon manufacturers of, say, cell phones or other mobile devices like Samsung or LG or Motorola says that if you want to use our apps, Google's apps, you can't take that open source code in Android and change it in any way that you want that would harm the configuration that allows the Google search engine to operate with Android. So let's take that as a restraint, as a real-world example.
So having proven this anti-competitive effect, using your framework from the Microsoft case in the DC court, what would the next step be?
So the first thing to do is to look at whether there's an anti-competitive effect. And I think the courts, the trier of fact, would find there's an anti-competitive effect, because what you do is you keep a rival search engine, internet search engine, from having access to the easiest way to distribute a search engine and have it preloaded on, say, a cell phone or other mobile device. So there's clearly, in my mind, an anti-competitive effect.
So what's the next step after that?
The next step after that is you'd look and see if the plaintiff has proven an anti-competitive effect, the burden shifts to the defendant to come up with a plausible pro-competitive justification. I don't see one. They could argue, as Microsoft did in the case by the United States, that they're protecting their copyright. The DC Court of Appeals in the Microsoft case said that that bordered on a frivolous argument, and it would be the same as saying that because I have a piece of personal property like a baseball bat, I can avoid tort liability because of my personal property. So I don't see a plausible pro-competitive justification.
So
let me just interject something. What do I mean by a plausible pro-competitive justification? It's not something that helps Google. A plausible pro-competitive justification helps consumers by lowering prices, increasing output, or increasing quality. That's what I mean by a plausible pro-competitive
Thank you, Mr. Cross. Returning to the original theme, what element of this anti-competitive action isn't covered by the current antitrust law? Oh, my apologies. Sorry about that. No further questions.
Ms. Magaña, you may cross-examine.
Sorry.
Thank you, Your Honor. Mr. Cross, you were kind enough to give us some background on your legal career and what you do now. Is it untrue to say that the majority of what you do is spent representing big corporations as your clients?
Oh, no.
Really?
No, the majority of my corporation, my practice is representing plaintiffs. right now I have 4 active antitrust cases, 3 are representing plaintiffs. And in fact, I'm very proud of the one case I represented in the 7th Circuit Court of Appeals that is in all the antitrust textbooks. I represented a small Iowa entrepreneur.
How kind of you. You also stated in your testimony by saying that current antitrust law is successfully regulating big tech right now and doesn't need changing. Yet our witness, Dr. French-Hodson, mentioned that there have been about 436 mergers and acquisitions by big tech companies in the last decade, and yet none of these acquisitions have been blocked. So can you please tell me how this is exemplifying regulation of these companies?
Well, we've talked about the merger guidelines. The merger guidelines have been very successful. What the merger guidelines do is allow private companies that are thinking of merging to look at the statistics, to look at the Herfindahl index, to look at diversion, to look at the ability to raise prices and do an analysis of their own under the merger guidelines. And you have a huge number of mergers that don't go through because they look at the way that the agencies are going to interpret the merger laws. So the guidelines have been very, very successful. So the fact that you have few merger challenges doesn't mean that the mergers aren't being regulated under the law.
Okay, if we're talking about regulation, then you have mentioned in your testimony that companies like Google and Facebook more recently have been getting sued by the FTC. Is that correct?
That's correct.
Okay. Do you agree?
Well, Google's been sued by the Department of Justice.
Okay, so by the federal government.
Right.
Okay. Do you agree with these lawsuits? Do you think that that's regulation in action?
Yes, I agree that I think the Google lawsuit is a well-founded lawsuit.
All right. Well, numerous lawsuits of these that you have mentioned have been getting struck down. So how is this regulation in action if they're not going through?
Well, the Google case is still very much alive.
Yeah,
Google,
it's pending.
Google did not even move to dismiss. They just answered.
Okay, and what were the reprimands on that? What happened to them?
Well, it's still under consideration. There is extensive discovery taking place. Subpoenas against Apple, subpoenas against other.
So since these have been brought up more recently, highly likely, and it is true that the Biden administration is the current administration under which these timelines of these cases have been brought up. Is that correct?
Actually, the Google case was brought under Trump.
Okay. So we've seen an increase in recent years, nonetheless, though, of regulation. Is that not correct? Against these companies, new cases being brought up that weren't happening in the past 50 years or so?
Not in the past 50 years, that's correct. Because they didn't exist 50 years ago.
Okay, yeah. So it's a good thing, though, that these cases are being brought up now, as we're seeing an uptick in regulation.
I agree, and that's my concept is that we don't need to change the antitrust laws, that the antitrust laws are up to the task.
But we do need to change the enforcement?
Well, you know, you have different administrations have different philosophies. I suppose we could do away with that and make it an independent,
different judges also have different philosophies.
Yes, but the whole idea is we get diverse judges and not just one philosophical judge. Of course, there's a Court of Appeals, too.
Do you think that monopolies are good or bad?
If you think about a monopoly, I think monopolies can be good.
And they can be bad.
Pardon?
And they can be bad.
That's correct.
Okay.
They do a bad act.
Yes. So can you explain the idea that you have now discussed of saying that the market will self-correct, there can be other competitors that will see a profit motive to overtake these larger companies. Can you apply or explain how that applies to the idea of tech monopolies when we see companies like Facebook and Google controlling 70 to 80% of the search engine market or of social networking, and they buy up all their competitors? How is this competition in action?
I don't believe that markets necessarily can self-correct without invocation of the antitrust laws. I think the
So they need laws to regulate because they
That's-
cannot self-correct.
That's correct.
Okay. That seems good to me. So how can the new firms displace the existing powerful firms without those laws, or what do these laws need to accomplish for those firms to have a fighting chance at competition without getting bought up?
Well, take the example I gave with Google. DuckDuckGo is a new internet search engine that has come on the scene recently, and they emphasize privacy. DuckDuckGo, if it was allowed to be put on new Android-based mobile devices would have a way to be distributed. The easiest way to be distributed to the marketplace is to be preset on a mobile device.
But
And so
they
if-
would only get preset on Android phones.
Right. So if the
Who owns Androids?
Android represents 70% of the mobile devices right now.
All right.
And so if the DOJ wins their antitrust lawsuit, as I believe they will, then the DuckDuckGo will have a way to enter the market.
Okay. I have a question about data privacy. So if we're looking at not Google, but Facebook, and we see that, for instance, Facebook has over 70% of the social networking industry. Do you agree with that?
I don't know the numbers, but I'll accept
Okay.
your.
Okay. And we've all heard the cases coming up about Facebook stealing the data of its clients and having huge data breaches causing problems for millions of users. Do you agree that those have happened, that there have been data breaches of users?
Yes.
Okay. Is this the standard that we should allow to continue to exist, and is this somehow better for consumers and for competition when Facebook is just able to buy up its competitors like Instagram or WhatsApp?
No, I don't think they should be able to buy other firms if the result is enhancement of their market power.
Okay. I'm glad we agree on that.
That's the antitrust laws.
Okay. The Trinco case. A quote from the Trinco case says, "To safeguard the incentive to innovate, the possession of monopoly power will not be found unlawful unless it is accompanied by an element of anti-competitive conduct." So what should we define anti-competitive conduct as? Or what does the legal interpretation currently look like with the Sherman Act?
Well, as I just mentioned, anti-competitive conduct under Section 2 is an increase of prices, a reduction of output, or a decrease of quality, which is basically a price increase.
Okay. The Sherman Act also says that I'm not interested in the level of what a contract that makes trade harder. I'm interested in how it has the guideline that it makes conspiracy to restrain trade or commerce illegal. Do you agree that that guideline is in there?
Yeah, absolutely.
Okay. So do you agree that firms are also able to collude with other firms to increase their pricing power and artificially raise prices on consumers?
Well, they shouldn't be. That's against the law.
Okay, yeah. Do you think that it violates that law? Do you think that that's conspiracy to restrain trade by inflating prices?
That's absolutely what my book is about.
Perfect. I'm so glad we're in agreement. So how is that currently restraining firms being able to artificially inflate prices?
Because an executive, like the Bumblebee executive, can be sentenced to up to 10 years in jail. That's a lot of time.
It is a lot of time for one executive, but what about other executives? When has this happened other times?
Well, it has. There have been a lot of
I have no
executives that
further
have gone to
questions.
jail.
Thank you, Mr. Cross.
Thank you, Mr. Cross. Ms. Peter, you may direct examine the next witness.
Thank you.
Mr. Montz, would you please describe for the audience your background and qualifications to testify on antitrust issues?
Sure. I've been practicing law, antitrust law, as a litigator for 33 years. I hold a BA from Yale, as Mr. Duckers mentioned, and I got a JD from the University of South Carolina in 1989. I've been litigating cases. And unlike Mr. Cross, I'll happily say on behalf of big corporations for many, many years, and continue to do so today.
We've discussed the objective of current antitrust law, the objective of the consumer welfare standard. Can you clear it up for us and tell us what the ultimate objective of current antitrust law is?
Sure. The purpose of the law is pretty simple. It is to it is anti-regulation. It is to allow the market to determine the outcomes of economic interactions. And the basic principle is just to protect the market processes which result in the highest output and the greatest quality at the lowest prices, all for the benefits of consumers. That's what it's there for.
What are the benefits to the consumers?
Well, there are a number of them, and there are a number to the society at large. The first and most important one is that it gives us a framework by which we can measure whether a practice is good or bad. Now, one of the things that struck me about the other side is they don't have any standards. They use terms that have malleable meanings like fairness or level playing field, but no one knows what that means. It means what any particular judge or any particular jury decides in a single moment. This provides an economic framework, a well-established and well-regarded framework based on price theory that allows us to measure the effects of a practice and ascertain their likely benefits and harms, and we know which one we're going to do. That's quite important. Why is it important? Well, Mr. Cross alluded to this. People go to jail if they violate the antitrust laws. And one of the things that is a bedrock principle, not merely of the antitrust laws, but of the Constitution of the United States, is you're to have fair notice of what it is that the law prohibits. The Consumer Welfare Standard gives us that. It gives us a standard by which we can measure and we can advise our clients and business folks who want to stay on the right side of the law can have a reasonable basis for ascertaining whether their conduct's lawful or unlawful. So that's the second thing. The third thing, and I was struck by Dr. French-Hodson's reference to Louis Brandeis, because this is the biggest problem, I think, that the standard adopted by the other side or suggested by the other side, whatever it may be, faces, and that is that the Consumer Welfare Standard is consonant with basic democracy. As Mr. Cross mentioned, people vote with their dollars. There's nothing more democratic than allowing markets to determine the outcome when we have millions of people every day voting with their dollars. Instead, the other side proposes to have a judge, one unelected judge, or 10 to 12 jurors, people who are chosen for their lack of knowledge about the matter at hand. That's precisely what we do. Decide a question. There's nothing more anti-democratic than that. And so those are the basic reasons and the benefits that we have for it, for the Consumer Welfare Standard. One other thing, and this also was mentioned by Dr. French-Hodson. She mentioned the term restraint of trade and talked about the text of the statute. In fact, it points the other direction. It points precisely to the Consumer Welfare Standard. The standards, the language of the three antitrust statutes all mention competition. The first statute, the Sherman Act, prohibits unlawful restraints of trade. Again, a commercial concept. It prohibits monopolization, an economic concept. We really see it, though, in the Clayton Act, which relates to mergers. Those are only unlawful when, as the statute says, they tend to create a monopoly or to restrict competition. We use the precise terms competition. Finally, and one thing I think Ms. Magaña just mentioned was collusion, and she seemed to be quite pleased that Mr. Cross agreed with her that cartels are unlawful. Well, the only reason cartels are unlawful is because we have a Consumer Welfare Standard. If we're going to say other things have to be considered, like labor or producers, well, then maybe we need to let producers fix prices. After all, if they can fix prices, they'll have more money, they'll be able to compete better with the Amazons and the Googles of the world. So if we're going to have a standard that prohibits cartels based on collusion, we have to have a Consumer Welfare Standard. It's the only rational thing we can have.
You've said we've tried the other side and it's failed miserably. Why?
It did fail miserably. Throughout the 1960s, and frankly, merger enforcement in this country was fairly non-existent until the passage of the Keller-Kefauver Act in 1950. And the reason for that was simply because that statute prohibited mergers, and so every smart lawyer would advise his client to not enter a merger, but to buy the assets of the other companies. So that wasn't particularly effective. That was changed in 1950, and we finally got some litigation in the early 1960s. Mergers essentially ceased because it was impossible to get a merger past the Justice Department, and so we had all sorts of problems. Small mergers, Brown and Kinney shoe stores, total market share 5% combined, unlawful. Pabst and the Heilmann Brewing Company, total market share 4.49%, declared unlawful. Vaughn's Groceries, 7.5% total market share, declared unlawful. One sort of loses interest in finding harm to competition and market shares, these small. But essentially, merger policy crashed, and there were no horizontal mergers. Dr. French-Hodson also mentioned the number of tech mergers in the recent years and said that they haven't been challenged. Well, there's a good answer for that, aside from what Mr. Cross gave. But of the ones that have been cleared, many of them had divestitures, and those that didn't have divestitures, the merging parties didn't compete with one another. They just simply didn't do the same thing. They were complementary products. So we tried that. That failed. Innovation ceased. Or I shouldn't say ceased. It didn't cease, but it was slowed. And we had a long period of stagflation in the 1970s. Only when, and there were other things, so don't get me wrong. I'm not suggesting antitrust policy changes were the only reason for this. But only when we saw the change from a very strict policy of essentially standardless antitrust enforcement, since no one could say what it was, to the consumer welfare standard, where people could actually start to plan rationally. Businesses could plan rationally. We saw a great explosion, great economic growth, and we saw the decline of prices to levels that we hadn't seen in many, many years. In fact, in the mid-'80s, gasoline prices, which is something useful to talk about today, were 85, 86 cents a gallon. Again, largely because we had a policy of pushing oil companies to innovate and compete, because that's how they were going to survive in the business. So we've seen what a standardless antitrust policy will do, and going back there, and there's really nothing new that we haven't seen before. This is just old wine in new wine casks, and so we're much better off where we are today, and that is, as Mr. Cross said, completely up to the task.
You've kind of mentioned this, but what would happen if right now we all of a sudden decide to increase antitrust law? How would it affect consumers? How would it affect the individuals here?
Well, I mean, I think the biggest aspect, and I love some of this stuff about big tech, because we talk about producers, and Dr. Sabarwal mentioned the Epic and challenge to the Apple store and the Google Play store. Well, one of the things that we're going to find, I think, is that if you tell Google that it can't charge the price that it charges for the Play Store, what we'll see is a degradation of the apps and the availability of apps. Google will have less incentive to ensure that the apps meet its exacting standards, and consumers will lose the benefit of the platform regulation that Google sees. Dr. Agarwal also mentioned Amazon favoring its own sales. Well, we can stop that, and then Amazon will have every incentive to raise the price of Prime to $159 a year, or to charge greater royalty rates to those who to sell on this platform. So the piper is going to be paid. The question is, are we going to let judges do it, or are we going to let consumers do it?
That's time. Thank you so much, Mr. Montz.
Mr. Scott, you may cross-examine.
Awesome. Thank you so much. So you began by talking about why the consumer welfare standard is the best framework, but there have been other frameworks aside from the consumer welfare standard that were used before its adoption, correct?
There was one and it failed.
Right. Okay, so I do actually want to talk about this. You talked about how the 1960s were this horrible era of antitrust enforcement. However, economic growth during the 1960s was extremely high. It was one of the most prosperous times of economic growth in America. Why was that the case if there was this rampant antitrust enforcement that you claim was unpredictable and harming consumers?
Oh, I'm not saying that antitrust is the only driver of economic growth, but the reason for economic growth in the 1960s can largely be traced to the tax cuts of the Kennedy administration. And that really offset some of the serious problems created by antitrust law. But it took us to a point where by the late 1960s, the Supreme Court of the United States had concluded that it was potentially unlawful for a company to offer low financing rates to sell its product.
Okay, so next you kind of claim that the consumer welfare standard and the adoption of it is kind of part of what brought us out of stagflation, part of what increased economic growth. I guess if that's the case, why have economic growth rates after kind of starting in the 1980s been far lower than the post-World War II era where we saw this rampant antitrust enforcement?
Oh, they haven't been lower. They've been quite good. And in fact, I suspect that if we ever have 2 decades back-to-back like the 1980s and 1990s with low inflation and with minor recessions at various points, we'd be quite fortunate. In fact, I think all of us sitting here today probably pine for those days.
Cool. Okay, I would like to move on now kind of to talk more about the consumer welfare standard. So am I correct that the way that judges currently apply the consumer welfare standard is mostly based on price levels?
Oh, no. It is based on output, which includes price, it includes quality, it includes any number of factors on which any company can compete. And that's the beauty of it. It's not limited just to price.
I guess I agree. Theoretically, the consumer welfare standard could be used that way, but that's not how it's being used. The way that it's being used right now is like a large overfocus on price, and we can see this in the examples we've been giving about the lack of privacy protections within Facebook due to a lack of competition.
Well, so, I guess I have interesting then. Maybe I need to hire you because I seem to have given away my privacy rights when I signed the media release tonight. And apparently at below market value because the consideration wasn't real high. So, no.
I think you're getting more money from the Dole Institute than from Facebook. That's a whole separate issue. So I guess what I want to really get to is how are these things weighed against each other? So let's say Facebook is able to provide a pro-competitive justification about how a merger could decrease prices. But the other side makes an argument that product quality within Facebook will decrease due to a lack of competition. How does the consumer welfare standard currently allow for these things to be weighed?
Oh, it's quite easy. We hire good, smart experts like Dr. Sabarwal who can quantify for us to a reasonable degree of certainty, and of course there's always going to be some trade-off, but which one is going to be likely to be greater? Is it going to be the anti-consumer effects, or are we going to have greater efficiencies? And the likelihood of one or the other is the outcome, and we pick the bigger one.
Cool. Another question. If output is increased overall, which is kind of the standard that you were talking about, but competition within an industry is decreased, I guess, would the consumer welfare standard allow for that merger action to be considered legal?
I think you've described the null set there. I can't see how output increases with competition decreasing overall. I can see how there can be price increases with output increases, but I don't think competition as a whole declines when output increases.
Okay, then I guess why is the American economy at its lowest rate of small business growth in decades, and why do companies like Google and Amazon have such huge market shares if competition should be increasing due to these mergers?
Well, competition, it's not mergers that built Amazon, Google, or Facebook. It's the fact that consumers like them, so they have big market share because they're efficient. And I would tell you that part of the reason we have innovation declines today is because venture capitalists and others can't be sure exactly what the antitrust regulator is going to do, and so they're not going to risk money when you can't predict what these folks will do.
Okay, cool. So your second point that you made was about how this is like the most democratic process. I guess first what I'm wondering is, how can consumers vote with their dollars when companies like Amazon are able to privilege which products consumers see first? Google is able to do the same thing. And there really is only one option for which social media you use, which search engine you use. How can they like fairly vote with their dollars in this form of an economy?
Well, Amazon, let's just stick with Amazon because they're each a little bit different, but Amazon's an easy one. Amazon's a big shopping mall. You know, now if a developer goes out here and across the street builds a big shopping mall, let's say Macy's does, and Macy's decides it will invite anybody who wants to sell, consistent with its space, into its shopping mall, but it's going to reserve for itself, you know, the best store location, because after all, it built the shopping center. None of us would think that's a problem. That's what Amazon does.
Well, I think the other stores might think that's a problem if
how
no one
are they,
is going to their store.
How are they hurt? They're not hurt at all.
They are hurt because, so I guess, let's say you're going on Amazon and you want to buy a new mouse, and you search mouse. The first mouse that comes up is going to be the Amazon Basics mouse. It's $10, it looks good enough. You're probably going to buy that and not the new cool mouse that's being innovated 5 results down, correct?
Well, maybe so, but that's because I value my time more than I do searching for the $5 mouse. I value my time more than $5. Consumers make those trade-offs between leisure and dollars all the time. And lest you think I'm wrong about that, I suggest you look at what wealthy folks do when taxes go up. They trade labor for leisure.
Cool. I guess another question I wanted to ask about democracy is you claim the current system is producing the best form of democracy. However, the 5 largest tech companies were able to spend $74 million on lobbying in 2019, and they exercise a major amount of control over the political information that people in this country receive. Why is that democratic, and how is that produced?
I don't think any of that's an antitrust problem. I mean, there may be other problems, and you can pass another statute to deal with it, although companies, just like the rest of us, have First Amendment rights to speak. But the fact of the matter is that the issue is who is to decide, and the question is that your side offers is a judge or 10 to 12 jurors. Our side offers millions and millions of consumers on a daily basis.
And I guess, what power do those consumers have now with these big monopolies that they aren't able to challenge?
Well, you know, I think Microsoft found out the answer to that question. In 1999, when the government brought its case, Microsoft was thought to be an impregnable monopolist. And what we found out is, lo and behold, a guy who builds a machine with some colorful plastic and a little thing that you can put music on could suddenly explode Microsoft's impregnable monopoly. The difference between us comes down to this, is that...
Mr. Montz, I'm afraid you're out of time.
Okay, thank you.
Cool, thank you.
Thank you, Mr. Scott. Thank you, Mr. Montz. We will now move on to closing statements.
Your Honor, counselors, ladies and gentlemen, on July the 2nd, 1980, the 51st United States Congress published an act to protect trade, commerce against unlawful restraint and monopolies. Named for Senator John Sherman, its principal author, we know it today as the Sherman Antitrust Act, a comprehensive charter of economic liberty aimed at preserving free and unfettered competition as the rule of trade. In 1914, Congress passed 2 additional antitrust laws: the Federal Trade Commission Act, which bans unfair methods of competition and unfair or deceptive acts or practices, and the Clayton Act, which addresses specific practices such as mergers and interlocking directorates. With some revisions, these are the 3 core antitrust laws in effect today. The question to be resolved here is whether or not antitrust laws should be expanded to regulate anti-competitive practices by big tech corporations? The answer is yes. Anti-competitive practices involve much more than just money. The Pew Research Center is a highly respected, nonpartisan fact tank that informs the public about the issues, attitudes, and trends shaping the world. In 2018, its survey found 68% of Americans believe major technology companies have too much power and influence in the economy, and 51% believe more regulation is necessary. Its 2020 survey found 72% of American adults say social media companies have too much power and influence in our politics, and that a majority of Republicans and Democrats believe social media companies wield too much power. The Open Market Institute, it's an organization that works to address threats to our democracy, individual liberties, and our national security from today's unprecedented levels of corporate concentration and monopoly power. Sally Hubbard, its Director of Enforcement Strategy, stated, "Americans need to know that big tech obtained dangerous levels of power, not by competing purely on the merits, but by illegally crushing and by manipulating how people communicate and do business with one another." In March 2018, the Harvard Business Review warned us of the potential harm dataopolies represent, proclaiming that the evidence is overwhelming that antitrust laws should be expanded to regulate anti-competitive practices by big tech corporations because of the danger not doing so represents to our wallets, our privacy, our autonomy, our democracy, and our well-being. The weight of the evidence has established that regulation of big tech corporations is absolutely necessary for our children's future, for our physical and emotional health, for our economic welfare, for the truth, and for our democracy. I want to thank, before I close, our expert witnesses, Ms. Ruth-Anne French-Hodson and Professor Tarun Sabarwal, my co-counselors, Ms. Catherine Magaña and Mr. Michael Scott, for their invaluable contributions to our presentation and to our audience, both here and on the Dole Institute's website. And I also want to thank the experts that work with Mr. Duckers, my good friend Mr. Duckers, and his fabulous students. You did a great job. It just wasn't good enough.
Mr. Duckers, you may close your statement.
Well, once again, I would like to associate myself with the remarks of the distinguished gentleman from Topeka. But in particular, I want to say to Will and Raina, Catherine and Michael, you guys were outstanding, and let's really hear it for them. And as I told you, these two are killers. They are killers. So let's talk about this proposition for a second. Regulate anti-competitive practices. You know what you didn't hear from the other side? Anything about anti-competitive practices or anti-competitive conduct. You heard complaints about data collection. That's not a competition issue. You heard complaints about Amazon giving itself the best location in the shopping mall as opposed to others. That's not anti-competitive. That's exploiting a competitive advantage you may have, but that's part of the competitive process. You heard about mergers that went through, but no evidence that any of those mergers were anti-competitive in any way. What you heard is what I told you at the beginning. This is Festivus. It's the airing of grievances by progressives in this country who want to use the antitrust laws for something they're not designed to use. Look, if you got a problem with privacy collection practices by Google or anyone else, pass a law to deal with privacy collection practice. Don't mess around with my antitrust laws that are driving this country. And if you want to tell Amazon that it can't be listed first on its website, pass a law to do that. It's not an antitrust standard. But here's what really struck me in the testimony from the other side. It was Dr. Gratterwall's statement that we should learn from our past, and indeed we should. So let me take you back in history and down a road you might find interesting. In 1969, based on exactly the sorts of arguments you heard from the other side today, the Department of Justice launched an antitrust suit against IBM, Big Blue. Big Blue was considered to be an impregnable monopolist controlling computing in this country at the dawn of the computing age, and we had to do something about it, and we had to break it up. And we heard all of these arguments about externalities and bad things that IBM did. The Justice Department litigated that case against IBM for 13 years. Now, I know this seems ridiculous to everyone here today that we were worried not that long ago about IBM as a monopolist, but in fact, we were so worried back in the 60s that we filed this lawsuit, or Justice did, and it went on for 13 years before Justice finally, after trying the case for 110 days, dropped it because it was a complete dead bang loser. Now, during the pendency of the IBM case, interestingly enough, there was a Harvard dropout, started a little computing company in Seattle, Washington. It ended up by the name of Microsoft, and Microsoft ended up completely stealing IBM's lunch money by anticipating the direction that computing was going when IBM didn't and innovated. A year after Microsoft was formed, another college dropout by the name of Jobs opened a little fruit company in Cupertino, California, called Apple that we're going to talk about a little bit later. Now, the point of this story is not that you should drop out of college, okay? That would get me in trouble here. The point is that innovation and competition comes from directions we can never anticipate. And anyone who is arrogant enough to think that they can predict the future or smarter than markets is making a mistake. Did we learn our lesson after IBM? We did not. We did not. This is like the 20-year locusts that come, the cicadas. They come back like every 20 years with these wacky antitrust ideas. And they came back in 1998 with the idea that, oh my God, Microsoft is a monopolist and it's going to completely control the development of the internet. They're tying their browser to the operating system, and we have to break up Microsoft. And the Justice Department ran out and litigated that case against Microsoft for 6 years before finally settling it with nothing more than a slap on the hand and no breaking up of Microsoft. And what happened during that 6-year period? That little fruit stand in Cupertino, California that Steve Jobs started in 1976, Apple, completely stole Microsoft's lunch. When we sit here and talked about big tech today, did you hear anyone talk about Microsoft on the other side? No, you did not, because competition has reduced Microsoft to a shell of what it once was. And we didn't need additional competitive measures or antitrust enhancement to deal with that. The market dealt with it, and existing antitrust enforcement dealt with it. But yet, we still do not learn our lessons from the past, as Professor Gratterwall said we should. So let's learn them now and reject this proposition, which will only harm consumers in the benefit of it. And here's the thing you always have to remember when you hear people talking about these sorts of issues. They're not looking to protect you. They're looking to protect some company that's inefficient and can't compete, and that benefits no one. So reject the proposition, and thank you all so much for coming tonight.
I want us to recognize the KU students again, Michael, Catherine, Raina, and Will. Very good job. Thank you to our expert witnesses, our counselors, the liberal from Topeka and the conservative from San Francisco. To our timekeepers, be sure and recognize our timekeepers who kept everybody well behaved. And I want to be sure and thank Sarah Stacy, our events director, who made all of this possible with many moving parts. Thank you to Sarah Stacy. Thanks everyone for coming out for this our last program of the season. and we look forward to seeing you again very soon. Thank you all.